The call came at 2 a.m., not to a newsroom, not to a campaign office, not to a law firm, to the personal cell phones of sitting United States senators. Their staffers woke them up with 3 words that nobody in Washington ever wants to hear in the middle of the night. It just happened. And within 60 minutes of that call going out, the parking lot outside the Supreme Court building was filling up with vehicles, attorneys, aides, reporters, people who understood immediately what this ruling means and who needed to be somewhere, needed to be doing something, because standing still in the face of what just came down from the highest court in America felt impossible. Because what the Supreme Court just did tonight is not a ruling that sits quietly in a law journal waiting to be studied. It is a ruling that moves, a ruling with immediate force, a ruling that is already changing what happens tomorrow morning in election offices, in states you have heard of and states you have not thought about in years. A ruling that every American who has ever stood in a voting booth, who has ever believed that their vote matters, who has ever trusted that the system counting their ballot is operating the way it is supposed to operate, needs to understand before another hour passes. This is not political. This is not about which party wins or loses. This is about something that sits underneath all of that. Something more fundamental. Something the founders put in the Constitution for a reason, and that the Supreme Court just fought to protect in the most dramatic way the court is capable of acting. We are going to tell you everything. Right now. Stay with us. Let us begin with the word that is echoing through every hallway of power in Washington tonight. The word that legal scholars are using. The word that veteran political operatives who have seen everything are using. The word that appears over and over in the emergency communications being sent between officials across all 50 states right now. Unprecedented. Not unprecedented the way cable news uses that word to describe anything slightly unusual. Unprecedented the way a constitutional law professor with 30 years of experience uses it when their hands are shaking slightly as they type their analysis. Unprecedented in the specific, technical, historically grounded sense that means this has not happened before. Not in this form. Not with this speed. Not with these stakes attached to it. The Supreme Court of the United States issued an emergency election ruling tonight. Emergency. That word in Supreme Court language is not a figure of speech. It is a legal classification with a specific meaning. It means the court determined that the normal process of waiting, of allowing cases to work through the appellate system on their normal timeline, would itself cause irreparable harm to something the Constitution protects. Emergency jurisdiction exists for situations where the damage from waiting exceeds the damage from acting immediately. The court acted immediately tonight, and the damage they were trying to prevent from waiting is the damage of an American election being conducted under rules that the Supreme Court believes the Constitution does not permit. Let that land for a moment. The highest court in this country looked at what is happening right now in the American electoral system and said, we cannot wait. We cannot let this continue through another normal cycle of legal procedure. Something is wrong enough, serious enough, constitutionally urgent enough that we are acting tonight. That is what the 2 a.m. phone calls were about. That is what is filling the parking lot outside the court. And that is what every American needs to understand right now. Here is how we got here. Because nothing at the Supreme Court level happens without a chain of events. And this chain is one that has been building tension for longer than most people realize. For the past several election cycles, a pattern has been developing across the country. Election procedures, the specific rules governing how Americans cast ballots, how those ballots are collected, how they are counted, and how the results are certified, have been changing. Not always through legislation, not always through the process the Constitution designates for making those rules, sometimes through executive orders from governors, sometimes through administrative decisions made by election officials acting on their own authority, sometimes through state court orders issued in emergency proceedings with limited time for meaningful challenge. Each individual change seemed manageable in isolation. Each one had a justification. Each one had defenders who argued it was necessary, appropriate, and legally sound. But the cumulative effect of all of these changes, made through all of these different channels, was a patchwork of election procedures across the country that had drifted significantly from the constitutional framework governing how election rules are supposed to be made. Legal challenges were filed, courts ruled, different courts ruled differently. A circuit split developed, meaning that federal courts in different parts of the country were applying different legal standards to the same constitutional questions about election administration. That inconsistency is itself a constitutional problem. Because if the constitutional rules governing elections mean different things in different federal circuits, then the constitutional right to have your election administered properly is not equally protected for all Americans. The Supreme Court has the authority and the responsibility to resolve circuit splits on constitutional questions. And when a circuit split involves elections, when the inconsistency is actively affecting how votes are being cast and counted in an ongoing election cycle, the case for emergency jurisdiction becomes overwhelming. That case was made to the court. The court agreed. And tonight, the ruling came down. Now let us talk about what it actually says, because this is the part that every American, regardless of politics, regardless of which candidate they support, needs to understand clearly and completely. The ruling addresses the fundamental question of authority. Who has the constitutional power to set the rules for federal elections? The answer the court gave is grounded in a specific clause of the Constitution that has been at the center of election law debates for years. The Elections Clause gives state legislatures the authority to set the time, place, and manner of federal elections. State legislatures, not governors acting alone, not administrative agencies making regulatory decisions, not state courts issuing orders that effectively rewrite election rules. State legislatures passing laws through the democratic process. The court held tonight that this is not a technical formality. It is not a procedural preference that can be bypassed when inconvenient. It is a constitutional requirement with real teeth. The authority to set federal election rules belongs to the legislature because the legislature is the branch of government most directly accountable to voters. The people who make the rules for how you vote should themselves be accountable to your vote. That is the constitutional logic. And the court said tonight that logic is not optional. The practical consequence of that holding is where the real-world impact hits hardest. In at least 6 states, election procedures currently in effect were not established through the state legislature. They were established through executive action, through court orders, or through administrative decisions by election officials. Under the framework the Supreme Court just confirmed tonight, those procedures lack the constitutional authorization that the Elections Clause requires. 6 states. Active election cycle. Procedures that may not be constitutionally authorized under the standard the Supreme Court just applied. That is not a theoretical problem. That is an immediate, practical, urgent crisis for everyone responsible for administering elections in those states right now. And that is why the phone calls went out at 2 a.m. Let us talk about what is actually happening on the ground right now in response to this ruling. Because the reaction is unfolding in real time, and following it tells you more about the significance of what happened than any legal analysis can. In 3 battleground states, courts have already received emergency filings tonight from parties seeking immediate orders requiring election officials to comply with the Supreme Court's ruling. Judges in those states are being asked to issue relief in hours, not days. Because there are not days, there are hours. Elections do not pause for legal proceedings. Ballots are printed, polling locations are staffed, mail-in ballots are in transit. The machinery of an election, once set in motion, does not have a clean-off switch. Election officials in affected states are making phone calls of their own right now, to their legal advisors, to their state attorneys general, to the secretaries of state who oversee their operations, asking the same urgent question that everyone is asking tonight. What do we do tomorrow morning? What procedures are we following? What has changed and what has not? And if something has changed, how do we change it in the hours we have before polls open or ballots are processed? Those are not easy questions to answer at 2 a.m. They are not easy questions to answer at any hour, but they are the questions that real people responsible for real elections are grappling with right now because of what the Supreme Court did tonight. In Washington, the political reaction has been faster and louder than almost any Supreme Court ruling in recent memory. That speed reflects how high the stakes are and how immediately everyone involved understands the implications. Officials who believe the ruling protects the integrity of the electoral process are calling it a historic restoration of constitutional order. They are using language about accountability, about democratic legitimacy, about the principle that election rules must be made through processes that voters can hold accountable. Their reaction is one of vindication, of a long legal argument finally being heard and agreed with at the highest level. Officials who believe the ruling disrupts election administration in ways that will harm voters are responding with alarm and with promises of immediate action. They are calling it destabilizing. They are arguing that changing election procedures in the middle of an active cycle causes exactly the kind of confusion and uncertainty that undermines voter confidence. Their emergency legal teams are already drafting responses. Their legislative leaders are talking about emergency sessions. Both reactions are real. Both reflect genuine stakes. And the intensity of both tells you something important. When the people who win a legal ruling are celebrating this loudly and the people who lose it are responding this urgently, you are watching a genuinely significant moment in American legal and political history. Let us talk about the justices themselves. Because the composition of tonight's ruling, who wrote it, who joined it, who dissented and why, carries meaning that goes beyond the immediate decision. The majority opinion was written with unusual directness for a Supreme Court emergency ruling. It does not hide behind procedural language. It does not bury its holding in legal technicality. It states clearly what the constitutional requirement is, why it matters, and why the court believes emergency action is justified. That directness is itself a statement. The court is not pretending this is a routine procedural matter. It is acknowledging openly that this is a significant intervention in an active electoral process and explaining why the constitutional stakes justify that intervention. The majority emphasizes repeatedly that this ruling is not about outcomes, not about which party benefits or which candidates win. It is about process, about the requirement that the process be constitutionally sound, regardless of who it helps or hurts. The court is staking out the position that constitutional process is not a tool for partisan advantage. It is a requirement that applies equally regardless of political consequence. The principal dissent argues with equal force that the timing of this ruling is itself a constitutional problem, that issuing an emergency election ruling with an active cycle underway creates disruption that disenfranchises voters who have been operating in good faith under existing procedures. The dissent argues that constitutional questions this significant deserve the full deliberative process of normal Supreme Court review rather than emergency action. That is a serious argument made by serious justices, and it reflects a real tension in election law, the harm of acting too quickly versus the harm of acting too slowly, the damage of disruption versus the damage of unconstitutional procedure. Reasonable people and reasonable justices can draw that line in different places. Tonight, the majority drew it where they drew it, and that drawing is now the law. For ordinary Americans trying to make sense of all of this, here is what matters most. Your vote is protected by the Constitution. The rules governing how that vote is cast and counted are supposed to be set by people accountable to you. That accountability is not a luxury. It is not a preference. It is a constitutional requirement that the Supreme Court just said it will enforce, even at 2 a.m., even in the middle of an active election cycle, even when enforcing it is messy and disruptive and generates 2 a.m. phone calls to United States senators. That is actually what a functioning constitutional system looks like. Not smooth, not convenient, not timed for maximum political comfort. Functional, principled, willing to act when the Constitution requires action, even when the timing is hard. The disruption tonight is real. The uncertainty is real. The emergency legal proceedings that are already underway are real. None of that should be minimized. People responsible for running elections are facing genuinely hard questions in a genuinely short time frame, and some of those questions do not have clean answers. But underneath all of that disruption is a principle that every American who believes in constitutional democracy should be able to recognize and respect. Elections must be run according to rules made the right way, through the right process, by the people the Constitution empowers to make them. And when that is not happening, the Supreme Court has not just the authority, but the responsibility to say so. Even at 2 a.m. Even tonight, the parking lot outside the Supreme Court is still full. The phone calls are still going. The emergency filings are still being drafted in law offices across the country. The election officials are still on the phone with their attorneys trying to figure out what tomorrow morning looks like. And in the middle of all of that noise and urgency and scrambling, one thing is clear and settled and will not change regardless of how the political battles of the next few days play out. The Supreme Court of the United States looked at the American electoral system tonight and decided that the Constitution it is sworn to protect required immediate action. It took that action. And the consequences of that action are going to ripple through American elections for years to come. You were here when it happened. You know what it means. And now you understand something that most Americans are going to spend the next several days trying to figure out. The 2 a.m. call already came. The ruling already dropped. The clock is already moving. And American democracy, complicated and contested and messy as it always is doing exactly what it is supposed to do. Arguing about what the Constitution means, fighting about who has the authority to make the rules, and ultimately deferring to a court that exists precisely to answer those questions when nobody else can. That is the system working, even tonight, even at 2 a.m., especially at 2 a.m.